so there's no problem.
Okay.
Okay. So shall we start?
Yeah, I think we
Okay.
should start now. It's time.
Okay. So a very warm welcome to all of you. And it's our profound privilege to find such a very, learned speaker who has done something on a very, very interesting area, that is graffiti and copyright. So graffitis are not a kind of thing which is not, that is so uncommon. It is pretty common. We are always encountering with it, but we are not realizing how they are being approached through copyright. So many times what happens, like it is being embedded, or you can say expressed on walls, which are, walls of any other person, and the person who is expressing his graffiti is someone else. So sometimes it is considered as an act of vandalism. So in that way, that fixation which has been made is not being properly realized by the people who are watching it or seeing it, and also not by the owner, like how he can, deal with it. So sometimes people take photographs, people use it for many other purposes, and having this very thing in mind that it is pretty common and open for use. So this has been a very tumultuous kind of situation with regard to graffitis, which has not been recognized in such a manner where you can say a proper realization of copyright could be found among the people. So there is something missing among the people also, who cannot realize it in that way, and sometimes it is not being paid that much heed due to various reasons. Like one of the reason is that, like, why one make a graffiti? There are various purposes regarding that. For sometimes to self-express his thoughts or something, sometimes for a wider goal of social purpose or political purpose. So having said that, people have this very thinking that because that has been made for that very purpose, so there's nothing wrong to use it, or to deal with it in any manner. So this very situation has been improved in the recent years, where some sort of legal framework has been provided to that. But still, the stakes of those artists who make the graffiti is still very challenging. So because of that, because we are dealing with the legal rights in legal aid society, so that is why these people who are the artists in that framework, they also fall in that domain where their rights are also at stake and not fully realized. So having said that, this very area is needed to be explored first of all, that what are the various dimensions of it, and then it must be given a proper legal framework so that those stakeholders must be protected under law. So having said that, I'm uh, you know inviting our professor in charge, Professor Raman Mittal, first to introduce this theme and welcome our guest. So over to you, sir.
Yeah, very good evening. Am I audible?
Yes, yes, very much.
Okay, so Professor Enrico Bonadio, Professor Shubha Ghosh, Professor Kshitij Kumar Singh, Professor J.P. Meena, my other colleagues at Campus Law Center, and my very dear students. It's my proud privilege to welcome you all. Graffiti ranges from simple written words to elaborate wall paintings and has existed since ancient times. In modern times, it is a rapidly developing art form. However, graffiti remains a controversial subject. In most countries, making or painting property without permission is considered by property owners and civic authorities as defacement and vandalism, which at times is punishable. But graffiti artists and graffiti makers, who are often marginalized and with no access to the mainstream media, resist this. They are of the viewpoint they want to display their art and political views in public locations through their mode of expression. The topics of graffiti range from love to satire, curses, wit, lament, fantasy, political opinions, social structures, and it has also become an instrument of dissent. Many graffiti also demonstrate a very high level of appreciation of art and poetry. We find it everywhere, but graffiti has a special relationship with public wall. In India, we often find it on highway trucks also. Graffiti may lie at the sidewalks of culture, but it is capable of and often enters mainstream culture by way of adaptation. It is a well-known fact that many film songs and many film scenes, especially in Bollywood, owe their origin to graffiti. That way, it becomes a powerful instrument of human expression. However, graffiti's legal status as a form of art has not been universally accepted and established, as Professor Kshitij Kumar Singh has just mentioned. The question remains open as to how and in what form to protect it under the copyright laws, especially when many graffiti makers choose not to reveal their identity for fear of consequences of offending someone, or they just don't care about it. They may not care, but should we also not care for this important form of human expression which exists at the frontiers of organized and recognized art? Friends, we are extremely thankful to Professor Enrico Bonadio for accepting our invitation. I'm sure that we'll have an intellectually stimulating evening, as this topic is often given not very much importance in the copyright classroom. Inspired by the subject matter, I have penned a small poem on the theme, and I would like to read it out for you. And I've just penned it in the last hour. The title of this poem is Hello, I am Graffiti. I come from the realm of dream. My views are often extreme. I don't belong to any organized team. I don't fall in the mainstream. But wait, I may still be worthy of your esteem. Look, I'm visual. I'm often lyrical. I'm always irresistible. At times I may be mimical. But wait, I may still be original. From the times of the Aboriginal to the age of the digital, people have been critical. Some even say I'm criminal. But wait, I may still be original. I speak the language of dissent. Often, anger I want. Unpopular may be my content, and my expression may be without consent. But wait, I may still have an argument. In public opinions, I play a part. A debate I want to start. Dissent I wish to impart. Though I am an unrecognized art. But wait, I may still have a heart. I call you with affection. I may not merit outright rejection. I am eager to be part of your collection. Though I don't care for perfection, but wait, I may still be worthy of protection. But wait, I may still be worthy of protection. Thank you very much.
Thank you, sir. Thank you very much for portraying it in a beautiful manner. And it is well aligned to the purpose of copyright to promote creativity in whatsoever form. So in that way, I mean, graffitis fall well in tune with that very criteria, which is already being there. And ignoring it or avoiding it, it means that we are non-inclusive to those subject matters and as well as those stakeholders who contribute a lot. So thank you very much, sir. And now I will be just going through the brief profile of our keynote speaker, Dr. Enrico Bonadio. So he is at present reader at the City Law School, City University of London. And his current research agenda focuses on copyright protection of unconventional forms of expression. So he will be reflecting many things which we usually miss out in our copyright discussion, including graffiti and street art. Dr. Enrico has recently co-edited the book, Non-Conventional Copyright, Do New and Non-Traditional Works Deserve Protection, together with Nicola Lucchi, Elgar 2018, and edited the Cambridge Handbook of Copyright in Street Art and Graffiti. He is a visiting professor at Université Catholique de Lyon and visiting lecturer at the WIPO LLMs in Turin, Italy, Ankara, Turkey, and Shanghai, China. He has been visiting scholar at the University of Melbourne, CUNY Law School, New York, University of Tel Aviv during 2018 and 2019, as well as Hokkaido University 2019 and Kyoto University 2019 in Japan. So with his profile, you can have that very idea that how much diverse his thoughts are and how well he is, how well he is versed with so many cultures, across the world, and so many facets of these areas which he's getting into. So without further ado, I welcome Professor Enrico Bonadio to proceed further with his lecture. Thank you very much.
Thanks so much, Professor Singh, and for the invitation to be here. Is an honor for me, invited by the University of Delhi to deliver this lecture. And I'm trying now to share the screen. I'm not sure. Can you see the slides now? Okay. Yeah. Great. So, as I said, very, very happy to be here with you, to be invited by the University of Delhi to deliver a talk on a topic which has kept me busy for the latest years. I've been researching the intersection between these forms of art, graffiti and street art, and copyright, of course. I also, not only I have looked at the legal analysis, the legal issues, but I have also conducted ethnographic research. That is to say, I have interviewed many street artists and graffiti writers. I have conducted participant observation, which is a method of collecting data. So I went out with them. I observed many artists painting walls, asking questions, of course, their opinion about copyright. And recently, as already been mentioned, last year I published this edited collection, the Cambridge Handbook of Copyright in Street Art and Graffiti, where contributors from all over the world have given their take, their opinions, and their legal analysis based on their jurisdiction. So they have analyzed 13 key jurisdictions, so how copyright protect or does not protect graffiti and street art in many jurisdictions. And then just a few days ago, I published a photographic book. So this is not an academic book. It's a photographic guide to copyright in street art and graffiti. Basically, I have tried here to explain with a few words and many pictures, many photographs, including photographs that I have taken during my ethnographic research. I've tried to explain the burning legal issues, right? The burning legal issues of copyright in street art and graffiti. So, having said that, as already been mentioned now today, wall writing, wall painting is not a new thing. It has been around since ancient times, Pompeii, Lascaux. Our ancestors have always felt the need to, write on walls. So it's not a new thing. I remember when I interviewed a London artist, a street artist, by talking about the anti-establishment nature of graffiti. And he said to me, but no, we are the establishment because we have been painting walls since 3,000 years. It's not a new thing, right? So let me give you a distinction here. There are two artistic movements here, graffiti and street art. Although the line distinguishing these two artistic movements is quite blurred nowadays because there are many street artists who also do writing, and there are many writers that do also, paint street artworks. I mean, there is a difference, right? This is graffiti lettering, basically the reinterpretation, the deconstruction or reconstruction of the alphabet. So graffiti writers, they write their names and they do it in a stylish way, right? These are letters. Sometimes they are not readable by the general public. They are just understandable and decipherable just by other writers in the community. It's a kind of secret code, but it's letter that we are talking about. These are letters. Letters painted in a very stylish and sometimes unreadable way, at least unreadable to the member of the general public. And then we have more figurative art, which is basically street art, right? Which may consist of stenciling, spray paint on freehand spray paint on walls. Usually figurative elements are part of street art, but not only painting on walls, also stickers, also abandoned objects. I mean, the typology and the taxonomy of street art is quite broad, let's say. But we will stick today to painting on walls because it's the most, let's say, common and widespread form of street art. Okay. Having said that, why do we need to bother about copyright and street art and graffiti? Well, we do need to bother because in the latest years, I would say 10, 15 years, more or less, there have been several cases, especially in the United States, but not only, where corporations from different sectors, fashion, food, cars, movies, real estate, publishing, have started targeting graffiti and street art, mainly by incorporating such artworks in their advertising message, right? Of course, without asking permission, without paying any royalty, blah, 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 blah. So, I mean, street artists and writers have started to fight back, especially in the US. So here I just listed a list of cases where artists have taken action. Most of these cases have been settled out of court, right? Especially in the US. So, for example, this is Tats Cru, a famous New York crew of muralists taking action against Fiat for the car maker, for the incorporation of their mural into an advertising message, a TV commercial. Then you have a German writer, street artist Cantwo, complaining not in court but just on social media about the incorporation of this, this character into this swimming track of the Spanish team, Olympic team at Beijing in 2008. This case, as you can see, a poster, and then the incorporation of the poster on this T-shirt. Then you have Hayuk case, again a mural, and then the use of the mural as a backdrop for a commercial settlement after the suit out of court. Then you have another case in America, a Miami-based artist complaining and taking action against this fashion company for incorporating, for exploiting the mural in commercials, settlement. A recent one, H&M versus Revok, here the case was started by H&M in the US, before the US court, New York, and the mural was painted in New York, and the artist, the writer, complained about the incorporation of the mural into a commercial, and H&M took action in order to get a judgment of, an acknowledgement of non-infringement. Then the case was settled and abandoned. there are several cases. The Rhyme versus Moschino, again, another fashion company, Italian fashion company, appropriating on this dress the mural, settled out of court. Another fashion company, Italian fashion company, Cavalli, using this mural on one of its dresses of the fashion products. Again, these three artists took action against Cavalli. Again, there was a settlement out of court. Another case settled in the field of eyewear, right? This case was quite particular because the corporation which was accused of exploiting the mural tried to defend the case by saying, look, this mural is not original enough, underfaced, the originality test underfaced in the US law. Well, it's quite a weak argument in my opinion, because it is, in my opinion, it is it satisfies the originality requirement under US law. So this objection was quite weak in my opinion. Anyway, it was settled out of court. McDonald's, so fast food, targeting graffiti writing style. As you can see, there has been this incorporation of this tag, in graffiti jargon is called throw up, and Dash Snow was the artist, creating this writing style, this tag. He died years before the action, so the action was taken by the fiancé, but it was not successful, not on substantive grounds, but on procedural grounds, for lack of jurisdiction. Again, McDonald's has been embroiled in this dispute for the incorporation of this tag into one of its restaurants. Again, there was a case, and the case, as far as I know, has been settled. Then, two pending cases now in the US of street artworks being incorporated into commercial. Chris William versus IV. Again, it's pending as far as I know. And another pending case, Julian Rivera versus Walmart. Walmart, the big company in the US, which had appropriated this artwork on fashion products. So many cases, especially in the US, but not only, also in Europe. So we now need to verify whether the originality requirement is met by these artworks, right? The originality required. Oh, of course, with reference to most street artworks, figurative artworks, there is no, in my opinion, there is no doubt about their originality, right? They are work of art, figurative work of art. So I don't think there is any doubt. But doubts may arise for graffiti writing, especially whether tags, sorry, I don't know what happened here, whether tags are considered original enough, right? Tags are the first things a writer learns to do. It's the first step in the artistic career of a writer. They learn about writing their name like this, then they evolve by then being able to learn how to write a more intricate piece, colorful piece. But the tag is the first thing, is the first step. Can we say that this is art, original art, so that satisfies the originality requirement? Well, most of you may say, no, that's not art. That's just visual pollution, scribble, right? And I don't blame. I mean, I also thought that it was visual pollution before studying the subculture, the artistic subculture. But we need to take into account that this subculture, I mean, tags are learned by writers at the beginning, and it takes years and years of practice to evolve and to write, a good tag, a nice tag, a beautiful tag. So one may say, no, that's not art. That's visual pollution. But if we see the same tag on a canvas, we may start thinking, look, that's art. That's original art. So, but it's the same tag. This is a writer I have interviewed in New York. Easy, a New York writer. He spray paints tags at night, illegally, of course, but then he also legally produces canvases with the same tag on it. So it's the same tag, it's the same thing. What is different is the surface, is the support upon which the tag is placed. But my point here is that, as far as I know, there is no copyright law in the world which imposes us to look at the support when it comes to assessing originality of the artwork, right? So my point here is that our assessment of originality might be corrupted, might be, biased, based on the support where the artwork is made. So on the left, one may say the one on the left is just visual pollution, but the one on the right, it's art, original art. Well, that would be a bias, in my opinion, because the support upon which the thing, the artwork, is placed basically jeopardizes and affect our assessment, which should not be the case. I mean, tags together could be really artistic, right? Look at this door full of colorful tags. And look at this wall full of tags. So, in my research, I want to push the arguments that whether or not a tag is original should be, determined by judges, for example, in cases, having in mind and taking as an expert, as an average expert, the graffiti writer, the average graffiti writer. Of course, if you ask about the artistic element of a tag, if you ask to the man in the street, he or she doesn't know. We need to ask to the average expert in the field, so the insider of these communities, right? Because there are tags and tags. There are stylish tags, and there are tags which are not stylish, which are merely scribbled. And these can be distinguished by people inside the subculture, who know how the style can be reached by these writers, right? So, having said that, let's go on. I mean, this American case was quite important. This was a case where a video game producer was accused of, incorporating in the video game some graffiti artworks, including tags, pieces, dip and dipism. So the tags in question were dip and dipism. Well, the judge did not find here, the court did not find copyright infringement, but Obiter expanded on the style of the lettering. Let's read what the court wrote here. The form of the lettering at issue is arguably central to the artistic expression of particular words. The unusual context aspect, in these unusual context, aspects of the lettering shown in the Rees art, such as the degree of abstraction of the letters, the connectivity of the letters, the relative size of the letters, and the 2- and 3-dimensional appearance of the letters, may reveal the artist's personal style and strongly influence the total concept and feel of the works. Very clear. Also said, although these words, these tags, are not themselves subject to copyright protection, the original manner in which Rees, the artist, the writer, expressed these words is protectable. The color combinations and arrangements of these words, of the way these words are being painted, may constitute protectable elements of that artwork. So, in my opinion, these are findings, very important findings, that could be used to push the argument that even tags or even what may be considered as simple writing could get the protection, could be considered as an original copyrightable work. What about the other requirement of copyright protection, at least in several common law jurisdictions, in the US, in the UK, fixation is a requirement for getting the protection. Well, we need to take into account that most of these of graffiti and street artworks are ephemeral, are provisional, temporary. Some artworks may even last just for a few minutes or even seconds, because they might be whitewashed, or I give you an example of reverse graffiti. Reverse graffiti is that artistic practice where the artist, basically they create by using dirty surfaces, for example, dusted surfaces, right? Such as in this case, this is a Russian artist, Nikita, and what he does is to use dirty surfaces and, you know, come out with wonderful artworks, right? Reverse graffiti. Well, reverse graffiti especially may last just for a few minutes sometimes, even seconds, right? So we need to wonder, we need to ask ourselves, is the fixation requirement met here? Well, let's look at the US, for example. The US Copyright Act says copyright subsists works which are fixed in any tangible medium of expression. Well, one may say, well, that's a transient, you know, taking into account the transient and provisional nature, ephemeral nature of these forms of art, fixation is not met. But in my opinion, this objection would be rather weak, because fixation in this context only demands works to be sufficiently permanent or stable to allow it to be perceived, reproduced, or otherwise communicated for a period of more than a transitory duration. Well, we need to interpret what, you know, transitory duration means. But my point here is that although ephemeral, the temporary existence, even for a few minutes, of these artworks is sufficient to meet this requirement, because even if we look at that reverse graffiti work for just a couple of minutes, in my opinion, it's sufficient to be perceived, to be reproduced, or otherwise communicated. Then we also need to take into account that photographic documentation may here help, right? May here help in preserving fixation, let's say, in freezing fixation. By the way, this artwork is an abandoned object by Singh. Singh is a British, is an English artist who leaves abandoned objects, especially miniatures like this, in public spaces, and then take pictures. He takes pictures, right? Which could be a great way to, you know, demonstrate fixation. Okay, let's move on. Let's talk about infringement issues, right? And the de minimis rule. There was a case in the US a couple of years ago, this case, where the artist, Gail, complained that the defendant had used his work in the TV series Vinyl without authorization. So basically there was a TV scene, a footage, and in public places. So during an episode of the series, the woman walked through the streets of New York and passed just in front of the graffiti style wars art we own, okay? Well, the artist complained by saying that's a complete infringement. However, the court found that there was no infringement because the use was just de minimis, just for a few seconds, which makes sense. And the court said that the de minimis exception applies even if the incorporation for just a few seconds is deliberate. So the deliberate nature of the incorporation does not prevent the de minimis exception from, you know, being applied, from applying. Very interesting case. What about another important issue, which is the freedom of panorama exception, right? In several countries, I mean, several copyright laws around the world, there are provisions on freedom of panorama. For example, in the UK, there is a section 62, which allows, third parties to reproduce, exploit, even commercially, sculptures and buildings which are placed in the public environment. Not paintings, strangely enough. But yes, what can be appropriated under the freedom of panorama exception are sculptures and works of architecture. A similar exception is also provided by the US Copyright Act, especially for architectural works. There is a kind of freedom of panorama exception, okay? In this case, Adrian Faulkner versus General Motors, well, the freedom of panorama exception for architectural works under US law was discussed. The artist, again, here complained about the incorporation of the mural in a commercial, no? In a social media commercial ad by this car manufacturer, General Motors. General Motors defended the case by saying that the design, the mural here was to be considered as incorporated into the building. And so allowing the appropriator to rely on the work of architecture exception. But the judge, the court, did not agree on this defense. No, it was not upheld. The court said there is no indication that the mural was designed to appear as part of the building or to serve a functional purpose that was related to the building. Instead, there is evidence that the artist, Smash 137, was afforded complete creative freedom with respect to the mural. Smash, the artist, was not instructed that the mural should play a functional role with respect to the parking garage. The building was a parking garage. Or that the design of the mural should match design elements of the garage. The architecture of the parking garage and the building were already complete before the artist started painting on it. That's very clear. There is no incorporation. The same facts, basically, are relevant in these other cases, started by Mercedes against 4 street artists: Jeff Soto, Max Gramajo, Daniel Borbandier, and James Lewis. Again, here Mercedes, which started the action, is defending his position by saying, yes, there has been an incorporation of this mural in the advertising message, right? On Instagram in particular. But the mural has become part of an architectural work of the building. As far as I know, this case is still pending. But, I mean, it will be an important case to follow, because depending on how the judge decides the case, here, the possible finding that the appropriator, the car manufacturer in this case, is able to rely on the freedom of panorama exception for architectural works, well, this would open the floodgates for other cases of misappropriation. So basically, advertisers in many sectors, in many industries would be, let's say, emboldened. They would feel that they are free to incorporate murals which are painted on buildings, right? So it's a very important case to watch. Okay, let's move on. Most of these artworks are illegal. Not all, but many street artworks and many graffiti artworks are still illegal. So they are painted there without authorization of the owner of the surface, right? Of the wall, of the support. Is it a paradox to give copyright to artists that commit a crime, right, while painting the wall? That's the question. Well, we need to take into account that the appropriator of street artworks, such as H&M in this case that we have already seen, or Moschino in this case we have already seen, what they have done, they have tried to rely on this exception, on this defense, by saying, look, these murals have been painted illegally, so there is no copyright. Therefore, I can exploit it commercially. That the illegal artwork, the illegal exception has been raised by appropriators. Well, some commentators believe that this is the case, and we should apply in these disputes the unclean hands doctrine, which means if you have committed a crime, if the artist has the hands unclean, dirty, the artist cannot ask the court to be protected under any kind of law, including copyright law, right? Unclean hands doctrine. It's an equitable doctrine, which is used in the US, in other countries, for example, in other fields, when there are serial killers that want to write a book about their crimes. In many American states, for example, I understand this is not possible. It's not possible to rely on copyright, for example, or to maximize profits out of these abstractly, in theory, copyrightable works, right? Well, in a case in the US, Villa versus Peirce, it was a case where a publisher has published a book incorporating some pictures of graffiti and street artworks. One of the artists whose artwork was in the book complained by bringing a case. Well, obiter, the court in that case, said that whether the defendant would be liable for copyright infringement would depend on the factual question of illegality, suggesting impliedly that it's important to verify whether an artwork has been created legally or illegally in order to verify whether copyright subsists. But it's just speculation here. It was an obiter in a lower court decision in America. I'm not a fan of the unclean hands doctrine myself. I think it's unsuitable to govern the creative process in this subculture. Because who appropriates the art, the street art in this case, and invokes this defense, H&M, Moschino, all these corporations, is not the victim of the vandalism, is not the victim of the crime which has been committed. If there is a victim, that's the property owner, who, however, is not involved in this kind of disputes. The property owner has not appropriated the artwork, right? So, in my opinion, accepting the unclean hands doctrine would be absurd. It would lead to an absurd result, because it would end up rewarding people, companies that are not victims of the crime. In other words, it would legitimize co-option of street art, but not its very creation. It would legitimize corporations, people copying, imitating, incorporating street art just because it is illegal. And it would not protect, it would not reward the very creation of the art, which is then appropriated. So, in my opinion, the process of creating the artwork should be relevant under copyright law. Copyright should be neutral, should be blind as to the way of creating the artwork. If I steal a pencil now, and with the pencil which I have stolen, I draw a wonderful drawing, why should I be stripped of the copyright? Why should I be denied the copyright? Why should I be denied the enforcement rights under the unclean hands doctrine? It would be unfair, in my opinion. There is no paradox, in my opinion. If I commit a crime by painting on someone else's wall without permission, I may pay the consequences of this act. I have interviewed many artists, many writers that have spent time in prison for painting illegally. They don't even object anymore because they know the law. They take it as a risk of the trade, as a risk of being a street artist and a writer. But why should the writer or the artist be denied, copyright or enforcement rights? I mean, I don't see contradiction or paradox. I don't see any contradiction. The artist could pay the consequence of the criminal act, but at the same time, rely on copyright to do the copyright that copyright allows to do, maximizing profits or controlling the use of the artwork, blah 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 blah. But one may say, is it really convenient for writers, artists that create illegally to come out and start a legal action? There is a risk there, right? The risk of being prosecuted. It's a kind of confession if you start a copyright action. It's me, no? Well, that's true, and many artists I have interviewed have confirmed that. I wouldn't take an action. Many of them, they have said to me, I wouldn't take an action if there is a risk of being, prosecuted. But many others have said, of course, after the statute of limitation expires, there is no risk of being prosecuted, so I could start a legal action. The interest in suing increases in this case after 6, 7, 8 years, depending on the jurisdiction, right? The statute of limitation jurisdiction. And indeed, for example, in this case, you will remember that it has not been the writer who has started the legal action because he was dead by the time the McDonald incorporated his tag. Who started the action was the estate, the fiancé, right? Well, what about moral rights, and in particular, the moral right of integrity? Could an artist and a writer rely on the moral right of integrity to try to preserve the street artwork? Or in case the street artwork is destroyed, ask for damages, obtain damages? We know that the integrity right is a moral right under Article 6 bis of the Berne Convention, which allows the artist, the author of the artist, to object to treatments of their works which are prejudicial to the honor and reputation of the artist. Well, there was a big case recently in America where the right to prevent destruction has been successfully enforced by 21 writers and artists. Well, I recap a bit what happened in this case. 5 Points was a very famous mural point in New York, in Queens. Many artists from all over the world in the latest years, until 2013 at least, went there to paint. It was called the United Nations, or La Mecca of graffiti and street art. It was legal, It was legal, it was not illegal. So artists there were granted permission to paint by the property owner. But then the property owner in 2013 decided to whitewash everything, as you can see from the photo, the picture on the right, which of course was considered by the artist as outrageous, and the artist took action against the property owner under the Visual Artist Rights Act in the US, which is an act which gives artists the moral right to prevent the destruction of the artworks, or in case of destruction, to obtain damages. And that's what the 21 artists who painted there asked the court in New York. And the judge sided with them. Mr. Block in New York judged with the artist, sided with the artist by saying and by writing, the property owner did not respect the procedure under VARA, and in particular did not send the 90 days written notice, which must be sent to the artist in order to allow them to recover before destruction those artworks that can be saved. And it seems that many of the artworks in question in this case could be saved, especially those that were placed on panels, removable panels, right? But the property owner did not care about anything. He just went at night and whitewashed everything, also the removable ones, without notice. And more importantly, the judge said that these artworks, there were just 45 artworks, object of the dispute. These 45 artworks reached the recognized stature requirement, which is the threshold set forth by VARA in order to get this protection. So the important aspect of this dispute was that graffiti artworks and street artworks were considered by the judge in 2008 and then the Court of Appeal a few months ago as having recognized stature. So in my opinion, one of the consequences of this case is that the gap between fine art and street art is narrowing. It has been the first time VARA has been applied to protect graffiti. And it has been the highest award, the highest VARA award since 1990, when the VARA was enacted, was passed by the Congress in America. So a very important case, a landmark case, I would say, in America. There is no doubt that there is tension between property owners and artists in these cases. There are two conflicting interests. On the one hand, the interest of the artist in, preserving the piece, if the artist is interested in preserving it. On the other hand, the interest of the property owner of, controlling their space, their support, their walls, and whatever. We need to find a balance, and such balance needs to be found on a case-by-case basis, by judges, by courts, when disputes arise, by taking into account many factors, including the existence of an agreement between the artist and the property owner, the length of time the artwork has been allowed to stay, the advantages obtained by the property owner as a consequence of the art placed on his walls, the public interest served by the proposed new use of the property once the street artwork is removed. For example, 5 Points, the New York Mural Point, was demolished in order to build up luxury condos, houses. Change of destination of the building, the adaptation to modern functional requirements, the cost of maintenance and restoration, whether the owner commissioned the work, whether the owner is an organization of which a moral duty lies to take good care of the cultural heritage, and so on and so forth. I mean, many factors should be taken into account when striking the balance between two conflicting interests. What about destruction of illegal street art? Because 5 Points was legal, right? They had permission to paint. Well, in this case, the issue of destruction of illegal street art was discussed. Well, you may think that's quite obvious and reasonable. Property owners who do not authorize, commission, who do not want artworks on their walls should be able to destroy them. That makes sense. Otherwise, said the court in this case, artists could effectively freeze redevelopments of vacant lots by placing artwork there without permission. And this is not what VARA should be about, said the court. That's very reasonable. However, in a subsequent case, Pollara versus Seymour, the court said that the finding in the previous case, English, only applies to illegal works that cannot be removed without destroying them, impliedly suggesting that in case of removable works, so works that could be removed, destruction may be prevented by artists under VARA even if the artwork is illegal. The court said that there is no basis in the statute in VARA to find the general right to destroy works of art that are on property without the permission of the owner. Very interesting case. So it's still, under US law, it is still a gray area of the law, whether or not illegally created artworks could be saved or not. Probably we need to wait for a Supreme Court decision in this case. Another interesting case was reached in Germany, 1995. It was a case of the destruction of an artwork removed from the Berlin Wall, right? In that case, the German Federal Court, said that the moral right of integrity is available even for illegal artworks, but can be enforced just against third parties, not against the owner of the tangible support, which makes sense. So there is little doubt that in certain circumstances, artists should accept the fact that placing their works on other people's properties may carry the risk of losing control over them, even when they have been authorized or commissioned to do that, right? We have seen that under VARA in America, if the property owner follows the correct procedure, for example, giving the 90 days notice, or another condition is for works that cannot be removed without destroying them, if the artist signs a waiver. Well, in this case, the property owner is able to destroy artwork legally. Also, property owners may be obliged on safety grounds to remove a wall or other surfaces where the artwork is placed. And of course, in artists' attempts to prevent the destruction of their artworks have sometimes been rejected by courts on safety grounds in France, in England, and in other countries, right? What about what I call the decontextualization of street art and graffiti? The removal of the artwork from the street, the surgical cut, let's say, of the artwork from the wall, and the relocation in an indoor environment. This has happened several times with Banksy, with Banksy's artworks. You know, Banksy is the most famous street artist in the world. There have been several cases. Other cases, this was a mural created by Stick, a London artist in Poland on the left, and then chopped pieces resurfaced years later in a West London gallery. Well, can artists rely on the moral right of integrity to object to these treatments of their artworks? Well, under USA and UK law, for example, it seems to be quite difficult. Or, I mean, it's still a gray area of the world, at least in the UK. In the US, for example, following some cases, including Kelly versus Chicago Park District, site-specific works, and the much street art is site-specific, are not covered by VARA. So VARA cannot be used here, which with the result that decontextualization of artworks, such as the ones we have seen in these slides, may not be fought under moral rights legislation. I wait for a ruling in other jurisdictions, could be UK, could be European continental jurisdictions, where the judge confirms that such surgical decontextualizations may breach the moral right of integrity of the artist. But I'm just speculating. Now, a more philosophical point. Is copyright fit to regulate street art and graffiti art? Because there are several commentators who believe that since most of these artworks convey an anti-establishment messages, I mean, graffiti, street art, much of these art forms of, most of these forms of art are anti-establishment. So artists and writers are not bothered about copyright. They don't like, I mean, they don't like copyright because it's a governmental tool. But that's a quite weak objection because, as I said before, copyright is neutral, right? And also there are several fine artists that are also very anti-establishment, and there is no doubt that the copyright applies to fine art. So it's a quite weak objection. Copyright not only is neutral, it is also flexible. It could be the tool to keep the message anti-establishment. In all these cases we have seen at the beginning, the artist or writer have complained about the use of their artworks by corporations such as fashion companies, McDonald's, and they didn't want to be associated with this consumeristic message. So they relied on copyright by starting an action, for example, in order to try to keep the message an anti-establishment, an anti-consumerist. So you can see how copyright is flexible here to try to avoid association with profit-oriented activities. And copyright gives this tool by, for example, way of an injunction, right? An injunction vis-a-vis the appropriator, McDonald's or incorporation. There are artists that authorize charities, organizations that are no profit, and they use copyright to regulate such uses. So, for example, again, this artist Stick, a London artist who is very well engaged with the social causes, what he does is to allow organizations such as the National Health Services in the UK, or homelessness organizations, charity organizations that fight homelessness, or LGBT charities, organizations. What he does is to allow these entities to use the Stickman, his iconic artwork. And he does so by having them sign a rule of usage, according to which these organizations accept that the Stickman should be used in a way which is approved by the artist. The artist can't do that because of copyright, and because copyright gives him the tool to control the use of his artworks by third parties. But you want to sell out as a street artist? Of course you can sell out, and copyright is there to help you selling out. Many writers and street artists do that. There are also many who don't do that. Of course, it's not an homogeneous subculture. It's quite heterogeneous. But I have spoken, interviewed many street artists and writers, even hardcore writers that go by night. They go on the city to bomb the city illegally, and during the day they do merchandising. They sell hats, T-shirts, umbrellas, incorporating their artworks. They do that for a variety of reasons: to sell out, to make profits, to put food on the table, to support other art projects they have. You can see how copyright is really flexible here. The fact that anti-establishment, could be used for several purposes, right? And in my research, in my scholarship, I'm trying to kind of humanize copyright in the subculture, and to make artists and writers understand how copyright could be useful for their own artistic career, for their own egoistic pleasure, or for any kind of purpose. I'm trying to raise awareness of this in the subculture. Graffiti and street art is also very much about appropriating and sharing, right? Appropriating style, sharing style, details, between peers, for example, mentorism, mentor activities are really common in this subculture. Old writers, old artists teaching young writers, young artists, and there is a kind of acceptance, of the reuse, the borrowing of elements, details. So appropriation and culture, also appropriation from popular culture, from advertising world, from other artists. Banksy, as you can see, the most important work by Banksy in Bethlehem, in Palestine, was based on a photograph by, I don't know who. I received this photo just a few weeks ago, but we still don't know who the photographer is. But you can see there is an appropriation here. Banks himself has appropriated the details of a previous artist who was Black Lerat, a French stencil artist, as you can see from these pictures, right? Many artists do accept such appropriation, especially when acknowledgement is given to the previous artist. As you can see from this mural, these street artists in New York recognize the source, right? A photographer. Of course, street graffiti artists sometimes may not tolerate blatant imitations, especially where there is no acknowledgement of the source, and there is reaction in these cases. But reaction often happens not in the course, of course, when when a writer is copied by another writer, of course, the writer does not go to court, but he or she relies on social norms, on street justice, which could be, for example, painting over the imitating artist, or shaming the imitating artist on social media by creating gossips about the imitation, or back in the days in New York, physical violence against the imitator, as it is emerged in my research. I want to now show you a dispute between two artists, one street artist, Banksy. Banksy back in the days was a graffiti writer, but back in the days. So Banksy as a street artist, and a very well-known graffiti writer in London, in England. One of the first graffiti writers in London in the 80s, Robbo. Robbo, as you can see here, painted in the 80s, I think it was 1984, 1985, this iconic mural, which has remained on the walls of the Regent Canal in North London for many years, more than 25 years, right? With some vandalism, of course, but it remained. Then in 2009, Banksy did this. Here was disrespectful by Banksy. This is not really accepted within the subculture. No, he painted over the iconic piece by Robbo, and Robbo reacted again by saying, "I am the king of the street of London," right? Of course, this caused the reaction again by Banksy, who said so, who painted this after that. Then Robbo again came and reiterated who the king of the street was. Then probably the council came and painted black. And then Robbo again painted an artwork teasing and mocking Banksy, rest in peace, Banksy's career, right? Then the council went back with the whitewashing, the blackwashing, let's say. Then Banksy came back with another mural, as you can see here. And then what happened, unfortunately, is that Robbo entered into a coma as a consequence of a domestic incident, right? And Banksy, the old rival, paid him a tribute by painting this, the original Robbo in Banksy style. And of course, then later, Robbo unfortunately died as a consequence of that, and his team painted the original mural of the 80s. So what happened here? What has happened is a conversation in the street, or a dispute, call it whatever you want, a clash between titans, between two big names in the streets of London. Of course, when Banksy intervened and painted over the Robbo mural, of course, Robbo did not go to court, but relied on social norms, right? On street justice. And the way street artists and writers resolve disputes by relying on social norms works. It works. Copyright has nothing to do with these aspects of the subculture, right? Street artists and writers don't take legal action against each other when these things happen, but they may be interested in copyright, so in starting a legal action or sending letters, cease and desist, when the imitator is starting making money. For example, by selling merchandise, incorporating the imitated artwork. Well, in my opinion, here we have the social norms which regulate certain aspects of the subculture, especially when money is not involved. But we have also copyright, which might play a role when money is involved. And this has emerged in my research. So I see here copyright and social norms as complementary, not as mutually exclusive, right? Once we accept that copyright is penetrating the subculture, we need to, artists and writers they need to stick to the rules of the game. They need to accept it fully. So, for example, they may lose cases they bring. In this case, Seltzer, a poster artist in Los Angeles, sued Green Day, the famous pop band, for the incorporation of the poster as a backdrop of their gig. But the judge there in the US said, it's fair use, it's transformative, fair use, there is no infringement. The street artist lost the case. Street artists or urban artists may also be condemned for copyright infringement. Here you have a case where Guetta, so-called Mr. Brainwash, was condemned for copyright infringement for copying the picture here. This specific work was not a street artwork. It was a studio work, but made by an artist which is considered mainly a street artist. The Court of California here said that there is no fair use, right? Again, Bush lost this case against Dennis Morris. Dennis Morris is an iconic photographer. And what Guetta here did was to basically stenciling an image which was a copy of the photograph of Sid Vicious, the Sex Pistols, singer. And he lost the case. Well, Shepard Fairey, a very famous street and studio artist, who became famous for coming up with the Obama Hope poster, you remember, in 2008. Well, that poster was based on a photograph of the then Obama Illinois senator, if I remember correctly, and AP, the owner of the copyright over the original photograph, Associated Press, sued the artist, Shepard Fairey. The case was settled out of court, but probably here the judge convinced the artist to settle because he would have lost the case, basically. So, some conclusions now. We have seen that copyright, in my opinion, is neutral and flexible, and so should be able to accommodate the interest of a growing number of street artists and graffiti writers, right? Also, these subcultures are experiencing an evolution. More and more artists are interested in copyright and also trademarks, we'll see in a few seconds, despite being anti-establishment artists. In my opinion, I see copyright as complementing social norms. So social norms as copyright do a great job both in regulating, in being capable of regulating the artistic process in this subculture. Also, we have seen that, the ephemerality as a structural element of graffiti and street art is evolving. This aspect is evolving. These subcultures are witnessing an evolution, and the 5-point decision epitomizes this evolution. We have seen there that 21 artists and writers have tried to fight destruction by starting the action under VARA. Of course, there is a need to balance the right of property owners with the right of artists, of course. And this must be done on a case-by-case basis by judges, right? So, and I conclude, is copyright for losers, as Banksy famously said in 2005 when publishing his book, War and Peace? Well, it seems that Banksy has changed his mind regarding intellectual property rights, because if Banksy seems not to like copyright, he loves trademarks, because he has registered through his organization, Pest Control, at least in the European Union, but also the US Trademark Office, several brands, several trademarks. These are a few examples of the trademarks that have been registered by Banksy through his organization. And also, I learned from colleagues that it seems Banksy is also enforcing his resale right for his studio artworks, at least. No? You know, he sells lots of also of paintings through the traditional art market channels, let's say. So I have concluded my presentation, and my last slide is dedicated to the University of Delhi, because I would have liked to be there today, but unfortunately these challenging times have prevented me from being there, but at least we have been able to do it through the online platform. So I thank you for your attention, and I welcome questions, doubts, comments, whatever, I mean, you think it's, you know, worth to demand. Thank you so much.
Thank you so much, Professor Enrico. And as you wish that you should visit, Delhi University, you will find that at the forefront, just opposite to that very building, you will find so many graffitis, which are being created by the students only. So that is pretty interesting for you, I guess. So I think you have comprehensively covered the various aspects of graffiti, and still there are some confusing points which may be, cleared in with the decisions or something, some developments. So the things which are very catchy are that, first of all, what comes to anyone's mind, that why graffiti is being created, the purpose, first of all. Like the creator, what is in his mind or her mind, that whether any commercial angle is there, or just, philanthropic purpose is there, or a social purpose is there. And whatever you say, that is very, very, crucial, that whether we are looking at copyright only in economic terms, or we are looking in a very, very wider aspect. So as you see, if you look at the perspective of, or you can say objectives of all the intellectual property rights, you will find that they are the artificial creation of a state to find out, to achieve certain objectives. So if you take that very purview, you will find that if you will be more accommodative, more flexible, you will not only incentivizing those people who are creating, but also accommodating them to enable them to have that expression on. So one can do it through the moral rights also. As you said, apart from that, we have to find out various dots which are missing, so that we can, fill in the blanks, and we will be more accommodative, providing, or you can say empowering those people who are making graffitis, because this is a case of clear empowerment, which I hope that one has to look into. So thank you very much for this, and we will be catching up with the questions. So some questions are in the chat box, so I will be quickly reading. So Professor Ghosh, if you wish to have some reflection on this, then you are most welcome. Yeah.
Yes, thank you. It was a very good talk. Thank you so much. I very much enjoyed it. There are lots of questions. I think it's a very fruitful area of research that you're doing. One issue, I think you touched upon this a little bit in moral rights, but when in the US we talk about right of publicity, and many of these graffiti works have distinct signature. I don't mean the signature in terms of the actual attribution per se, but they're distinctive, and they represent sort of a public side for whoever the creator is. So I was wondering if maybe Professor Bonadio would want to comment on the right of publicity aspect of this. Some of that is reflected in the moral rights discussion that he did, but there are separate right of publicity claims, it seems like, that would arise. And one also thought I had that's very interesting is many you touched upon this at the very beginning when you were talking about the LAS-CLC and the Pompeii and the history of graffiti. And one of the things that's very interesting when we're thinking about the history of the art is when we've created different spaces for art, such as the museum, such as the gallery, both private and public. And so I think in this story about graffiti, there's also an interesting story about the development of the institution of the museum. And I know some cities have created spaces that are dedicated for graffiti. So it's no longer just the graffiti is permitted within this particular space. So I was wondering if Professor Bonadio also had some thoughts about, he touched upon it a little bit when he discussed the private property rights, the real property rights, but generally the way in which we think about graffiti as reflecting attitudes towards space for art more broadly. So one question or thought about right of publicity, and then another question about museums and other spaces that are dedicated for art. But
yes,
thank you. It's an excellent talk.
Thanks so much, Professor Ghosh, for your comments and the questions. I started from the museum issue because this is quite delicate issue. There has been in the latest year there has been a debate going on about whether graffiti and street art should enter the museum. Right? There are already in Berlin, in Miami, graffiti museums or street art museums. Well, I must say that in this specific regard, the subculture is quite divided. There are hardcore, let's say, graffiti writers or hardcore street artists that still think that when graffiti enters the museum, ceases to be graffiti. It becomes another thing, right? So all these surgical removals of works and of mural and the relocation of museum have been condemned by many practitioners of real graffiti, of real street art. But this is not the homogeneous position, I would say. In my own research, I have interviewed not many, but some both writers and much more street artists that can't wait about their mural to be detached and put into a museum. Because the museum is the place where the artwork is sanctified, where is kind of worshipped, no? But I mean, we can't say that there is a unique voice in the subculture. There are different voices. It's a quite varied and heterogeneous community. Also, those museums and galleries which have incorporated the graffiti style artworks, they try to abandon the white cube experience. The white cube experience is the typical traditional fine art gallery or space. Everything is white, quite cold, not cold in terms of the temperature, but cold as an environment. Well, when it comes to graffiti museums and graffiti galleries, the setting is completely different from the white cube. The organizers of the museum or the gallery, what they try to do is to recreate a street environment within the indoor environment by, for example, introducing some bricks or walls which remind the viewers about the street, right? Or the drips of the spray paint on the walls. I mean, they try to turn the white cube into a street-like environment. Whether people like it or not is another question, right? And whether we should consider these artworks as still as street artworks is another matter. In my opinion, we cannot use the definition, the term street art, when it comes to artworks, either artworks which have been removed from the street and relocated into galleries, or whether there are canvases or other surfaces painted in the gallery by street artists. In my opinion, it's not street art anymore. It's a street art flavored art, let's say. Like the souvenirs that are sold in the markets, right? The street art souvenirs, let's call it. But I mean, it's something which is it's a phenomenon which is expanding. I say again, Berlin, Miami, and there are other. And I mean, we need to accept it. Whether the hardcore street artists or graffiti writers accept it is another question. And the first question was about publicity rights and trademark rights. Basically, in some of the American cases I have highlighted, most of them they've been settled out of court. Okay. But the artist or the writer through his lawyer, they have not only complained about copyright infringement, but also about the fact that their signature had been removed from the mural, from the appropriation of the mural. So, and they have tried to push the argument that the removal of the signature was a violation of the DMCA on management the corporate management information, right? I'm not sure how strong this objection could be because, first of all, it's not a digital environment we're talking about. But as far as I know, trademarks and publicity rights have not been relied on in these cases. Banksy, in my last slide, as you have seen by my last slide, Banksy has relied on trademark law to try to stop people and companies which sell merchandise, reproducing his art. But in a very recent case, before the European Union Intellectual Property Office, the EU IPO, one famous Banksy, a trademark reproducing a famous artwork by Banksy, the Flower Flower. I can get it again. I don't know if you can see here, but I need to share again. I need to share again the screen. Just a second. Basically, in this artwork has been incorporated into a registered trademark, the Flower Flower. Well, it was declared, it was cancelled by the office, by the EU IPO, the trademark office, because it had been filed in bad faith. That was what the EU IP office decided. It had been filed in bad faith because it was basically just a way of, I mean, also a shop was opened by Banksy when the cancellation action was started by a competitor, and it was a shop which was opened by Banksy just in order to create the evidence of the use to, fight the cancellation action. So, coming back to your question, Professor Ghosh, I think whether street artists and graffiti writers can rely on trademarks or publicity rights to protect their art, I find it quite difficult at the moment. I think copyright is the best way, is the best legal tool. Of course, one thing they need to do is to reveal his identity. Now, if they want to start a copyright action, they need to reveal this identity. And that's why Banksy so far has not relied on copyright in the few legal actions that he has started. Why? Because if he relies on copyright, if he files a copyright act, he will need to reveal his identity. And we know that anonymity is very important for Banksy because anonymity gives value to his art, right? And if he starts a legal action by relying on copyright, pest control, his organization starts a legal action based on copyright against an infringer, an alleged infringer, the first defense that the alleged infringer will raise is, I want to see the contract. No, a kind of locus standi defense. I want to see the contract through which Banksy has authorized his organization to enforce the copyright, right? And of course, the contract should reveal the name. That's why he doesn't want to do that. I hope to have addressed your question. Fully.
No, thank you. It's very helpful. It's a complicated issue. I mean, I think one of the things I was trying to get at it with right of publicity, I don't want to belabor the point too much, but one of the aspects with right of publicity with some of this graffiti, especially the, I forget what you called it, the small writings and, you know, those types of things,
tags.
Which may not have the, pardon me?
The tags, there's more writing there.
Yeah, the tags.
Okay.
The tags, yeah. I mean, the thing about graffiti, especially when you see them in the cities in the U.S. as I've seen them in Europe, is they themselves are representing. I mean, people know who have made it. I mean, obviously Banksy has an anonymity, but it also is a representation of his own publicity. I mean, if you look at the notion of what's protected under publicity, it's some notion of a public image. And depending upon the statute, that public image can be reduced to something like a name or a likeness or a voice. But the notion of protecting publicity is protecting the public image, and that is what graffiti is. Even if you're anonymous, and I'm talking more theoretically here because we need to look at individual statutes and how jurisdictions grant protection to publicity. But that's what strikes me about publicity. I'm not denying that there's copyrightability perhaps in some of these works, in many of these works, but certainly with tags, they serve as some sort of a, I use the word signature, not in the trademark sense or even in the attribution sense, but as the kind of the public image of whoever is the creator. And that is what publicity rights are supposed to protect. And that's what I was getting at. I mean, I think publicity rights somewhat are being criticized now because of the First Amendment issue, but the very act of expressing through graffiti is an expression or a creation of that public image. Now, I'm sorry, just to finish that thought, I don't want to monopolize this, but in the U.S., there would be a problem of preemption or conflict between right of publicity and copyright. So I know there are cases where the right of publicity claim has been lost because it conflicts with copyright preemption, but that may be different in other jurisdictions where this idea of protecting the public image has maybe different legs than in the U.S. But your answer was excellent, and thank you. And
thank you.
I think there's so much to discuss here.
Thank you.
So thank you. And there are a couple of questions. So I will be just asking, Raghav, are you hearing me? Hello.
Yes, sir. Yes, sir.
So can you just unmute those two of the participants to ask very quickly? I mean, they have very elaborated, question here. So ask them to quickly ask a pointer to Professor Enrico so that we will be finishing it in time. Okay.
All right, sir. 1 second.
So first one is from Dr. Vikas Bhati. And in between, they are asking for your PPTs. I mean, so I'm not sure. It's your domain. So
the PowerPoint.
Yeah, PowerPoint.
Yeah, of course I can share it. I can send it to you.
Yeah. That's okay.
Afterwards through a link, and then you can
yes.
You can send it to the participants. Yeah.
Okay. So nice of you. Yes, Vikas, are you there?
Yeah.
If he is not, then
there is a question in the chat.
Yeah, that is the question.
From Shataski Agnitotri. Should copyright infringement only be subject to concern when it involves monetary benefits, or it should be more flexible with moral rights also? Well, as I said, I mean, moral rights, in my opinion, should be recognized to street artists. So I would like very much the idea of a judge explicitly confirming that street artists in general, they are able to save their artwork from destruction. I mean, I say that because the VARA provision is exceptional to US. The right to prevent destruction under VARA is just specifically is very exceptional, because in other jurisdictions, I know in India you had a case about Singh, the Singh case, I remember, about where the Indian judge said that the artist could prevent the destruction of the art under the moral right of integrity. But it was an exceptional case, I understand. In other jurisdictions, there is no, I mean, the UK Corporate Acts in continental Europe, there is no specific right to save, to rely on, you know, on the moral right of integrity to save the artwork. Judges have interpreted, sometimes, you know, with the conflicting decisions. So I think it's important to give the option, at least. I mean, many artists would not be bothered about preserving it. This has also emerged from my research. Many artists and writers I have interviewed, they don't really care about their artwork being saved. They are just happy with the photograph, with the picture, which is normal, no? In graffiti, in the graffiti community. You do the mural, you take a picture, you post in social media, and that's where the artwork lives and keeps living. So many don't really care, but others may care, especially more time you have spent on a piece, let's say 2, 3, 4 weeks, more interest there is in preserving it, because you have spent time, energy, money, because many artists, they pay themselves the paint and the tools. So I would give the artist this instrument, which could be a non-economic instrument. Moral rights are not, I mean, the right to preserve, but we know that the moral right of integrity can become economic, with economic connotations, because we have seen in the 5 Points case, the artists, the 21 artists, relied on moral rights to get $6.7 million in damages. $6.7 million in damages for the illegal destruction of their graffiti. I mean, it seems the word upside down, no? Because usually graffitis are the vandals, right? And they are perceived as the criminal. But in this case, not only they were painting legally, but it was the property owner who was the vandal by illegally destroying his artworks and triggering this procedure, which ended up in $6.7 million awarded to 21 artists.
So let's take the final one, and it is from Maria Goretti. So
yes,
unmuting,
yes.
you can ask directly.
Yes, I'm reading the question by Shabbat.
No, it's by Maria Goretti. So
Maria,
are you there?
Maria, okay. Statute of limitation in the case McDonald's. Yeah, in the case of McDonald's, okay, can McDonald's claim copyright of its graph? You mean, are you suggesting, Maria, are you asking if McDonald's can claim copyright over the appropriated work? I mean, the work which has been put on its restaurant, because that work was created by the writer, by the artist. So I have not clearly understood that. And then the second thing, is the law on graffiti more or less the same across the globe? No, it's not. It's not. There are some differences. For example, regarding protection of illegally created artwork, which is still a gray area in several jurisdictions. The right of to prevent destruction, as I said, it changes depending on the country, so it's not the same. Then Maria asks, can you elaborate on how to insert the support surface requirement to the title? I don't understand here. I mean, in some jurisdictions, Maria, as I said, there is a fixation requirement. US, UK, I guess also Indian copyright law, right, does have a fixation requirement, which means you need a tangible support. And you need the work to stay on that tangible support for a period which is enough to make the work perceptible, so communicable.
I think that you have spoken for long hour. I mean 2 hours or something.
Yes.
I will be just asking Professor Raman sir, do you have anything to say? Raman sir? Sorry, I have to unmute. Yeah. Yes.
So, okay, thank you. So it was very nice, intellectually invigorating conversation with you, Professor, and we are very happy and thankful to you. You talked about fixation in relation to graffiti. You talked about commercialization of graffiti, the aspect of permission of the artist, the street artist, and especially permission for integration of the street art and graffiti into mainstream artworks. And you talked about the theory of unclean hands and gave the example of a person stealing a pencil and drawing an art. Well, the aspect of stealing the pencil and paintbrush should not criminalize the art. That's a very important point that you made. And of course, especially moral rights and the possibility of their commercialization also is extremely important. So we all are extremely benefited by this discourse on a very special and niche area of copyright law, graffiti, right? Thank you very much from my side and on behalf of Delhi University and all the students, we are extremely thankful to you. And as you said that you would like to come to India, we would definitely like to host you very soon after the pandemic is over. And definitely we'd like to invite you. You are most welcome. Very much.
Thanks so much. I'm very happy. Very
okay, so
to be here, and I hope to visit your school soon.
Okay, so formally, I'm on behalf of Campus Law Center Legal Aid Society as University of Delhi, I'm thankful to you and other participants, especially Professor Subha Ghosh, who has taken time in the morning, early morning, to catch up this very webinar. So I'm, expressing my special thanks to him. And because he was so eager to, hear you, that is the reason for him that he was,
Thank you.
joined us. He has joined us, and we will be engaging you on different topic. I think we will be, exploring the areas where we can interact more and more. And you are also a part of our collaboration, that is book also. So I'm very thankful regarding that also, the book on Gandhi and IPR. So in that way, we are just, pushing that thing also. So we'll be finding out how we can interact more and more and collaborate more and more.
Yeah.
So thank you so much.
Absolutely.
So thank you.
Thank you so much. Bye-bye. Bye. Bye.